Here from Houston, Texas. Every Tuesday, we bring in immigration updates. Today, along with me, is my business partner, Rebecca Chen. Rebecca, let's discuss about the trends in the I-485 adjudications. As you know that a lot of the people have filed the 485 applications in October of 2020. Of course, there are some people who filed afterwards. What's the trend right now, though? Specifically, if the case is stuck with the Texas Service Center and Nebraska Service Center, are they approving the cases there? Are they transferring it to the National Benefit Center?
No. So pursuant to the announcement they made in April a few months ago, any I485s employment-based that are pending at the Texas or Nebraska service centers, once they become eligible to be approved, meaning the underlying I-140 is approved, the priority date is current, biometrics and background check are done, USCIS is transferring them from Nebraska and Texas to the National Benefit Center for the final adjudication. So they're not really getting processed anymore at Nebraska or Texas. They're being moved to Nebraska, to the National Benefit Center. And USCIS actually provided an update to their frequently asked questions. They have an FAQ page specifically on the subject of employment-based adjustment of status applications on their website, and they made an update to that page at the end of last week. And in that update, they mentioned that they have transferred, I think, about 67,000 cases in that category from Nebraska and Texas to NBC, but they are still working on transferring them. So there are still some that have not yet been transferred. So if you have not yet gotten a transfer notice, don't worry too much. USCIS says that they are still currently actively identifying those eligible I-485s and moving them over to the National Benefit Center.
And Rebecca, what about this thing where we're getting a message that we are temporarily pausing work on your application because an immigrant visa number is not available for you? What does this mean, though?
Yeah.
And even if the final action dates are current, though, what is this all about?
Yeah, it's a very confusing message. It's very misleading, and actually USCIS addressed this in the same FAQ page. They basically say that it means almost the opposite of what it sounds like. They said that it doesn't necessarily mean that work is being paused on your case if you see that message on the online case status. So what USCIS explained was that basically in their system, they do not yet have, in the case status update system, they don't have an option yet for confirming when something has been successfully moved from EB3 to EB2. They don't have that transfer of underlying basis status programmed into their system. So when a case does get moved into EB2 perhaps, and then the case is transferred from Nebraska or Texas over to the National Benefit Center, that message, that paused work message, is the default that ends up appearing in your online case status, because the last action it basically means there was action taken on your case, usually the transfer of the file to the National Benefit Center. But because they don't have something programmed in there that says, you know, you're in EB2 now and we're processing your case, the online case status just automatically defaults to that message, which means almost the opposite of what is actually happening. So yeah.
Can I ask you a question? Can I send some of these H1B guys to fix those bugs?
Yeah.
Can they volunteer, please?
Yeah, it seems like it should be a pretty simple thing to update in the case status, and the fact that it means almost exactly the opposite of what is happening is very confusing to a lot of people. But I guess
of course they won't
addressed
accept the volunteer guys. Otherwise I would have sent some of you guys to fix those things. I bet you will definitely fix those kind of bugs. But anyway, you know, they don't employ H1Bs, and that's how it's going to work out. Rebecca, what do you see the trend when cases are getting transferred from Nebraska or Texas Service Center to National Benefit Center? How much time is it taking for the USCIS generally? Not 100%, but 90% of the cases, though.
Yeah, based on our observation, it's a matter of months, really. I would say sometimes as short as 1 or 2 months, up to about 6 months from the time it gets transferred to the National Benefit Center. Cases are getting adjudicated within 2 to 6 months.
And also we have seen very less number of people who are getting the 485 interviews. Most of the cases are getting adjudicated directly, though. We've also seen a lot of trend, especially in the month of May. We have seen a lot more approvals than compared to that of April of 2022. And if we compare that to the last year of 2021, definitely a lot more pace than what they have approved in the month of May. We see that the pace has improved in the month of June. Hopefully so it's going to continue though. What did they say about 280,000 green cards? Are they going to issue the 280,000 green cards, or how many are they going to waste though?
They haven't said how many they're going to waste, but they did update in this in the same FAQ page that there are approximately 280,000 employment-based immigrant visas available for this year to be issued by the end of fiscal year 2022, which ends September 30th of this year. And they have reiterated their intention to use as many of those green cards as possible by September 30th. They also listed kind of some of the measures they've taken to try to achieve that. They've also listed some reasons why it has been going somewhat slowly in that same frequently asked questions page. So they haven't committed to using all the numbers. Their position right now is that they are trying to use as many as possible. And I believe their most recent statement to AILA was that they feel confident that they can adjudicate the I485s that are eligible to be adjudicated if they were received prior to June 2022.
Rebecca, have you, what about if the people have filed an I-140 and EB3 in 2020, can they now interfile in EB2 even if the I-140 is not approved? Now, I know that we can do it though, we can interfile it, but have you seen any approvals where the underlying I-140 is not approved yet?
Not yet. I haven't seen any I-485s approved where there was an EB2 interfile and the I-140 downgrade in EB3 is still pending.
So we still strongly recommend all the people, if you have interfiled though, and your underlying I-140 is still pending, that is the one that you filed in October or November or December of 2020, please do the premium processing. An update for you that they're accepting every premium processing right now. So initially they have not accepted the premium processing for most of the cases. Some of the cases we had to file 15 times to get it accepted. But starting somewhere in April though, they have accepted every premium processing case that we have filed. So it's an opportunity for you to get the I-140 approved. We have not seen 485 approvals if the first I-140 has not been approved. Although in the FAQs of the USCIS, the USCIS is telling that if you interfile the medical, they don't guarantee that it will reach the file. We've been telling the same thing. It's not a guarantee that it will reach the file, but our advice to you is that when you go to the medicals though, try to get 2 original copies though. One, you file it, interfile it. Second one, you keep it with you. If there is an RFE, you can respond. Previously, the USCIS was telling that the medicals were only valid for a period of 60 days within which you have to send it to USCIS. But they changed the rule until September of 2022. The medicals are valid. So even if it's been more than 60 days, they're still valid. So if I were you, I would get 2 sets of medical, do the interfile. We have had so many people who thanked us saying that, hey, I got my green card because I interfiled the medical. So you avoid the RFE that they will issue, which is good news. I mean, if a RFE comes in or a request for initial information comes in for medical, that's a very good news for you guys, obviously. But we don't want to waste that extra time, because once the officer touches your file, we want everything to be taken care then and there itself. We don't want him to, okay, issue an RFE, then you respond to the RFE, then the mail goes back, and then a lot of time is wasted in it. We want to use all 280,000 green cards though. Anything else on the trends of the 485 though? What's going on?
Yeah, those are, kind of the main trends. They're still transferring some cases. That they basically confirmed that if you have a pending I-140, you can still request the transfer to EB2. You can still request the interfile. But we just don't know that they will do the final approval of the I-485 if the EB3 I-140 is still pending.
Rebecca, we're noticing green card approving in wrong categories though. I have had clients file 485, and let's say, for example, he is working with company B. Company B has only EB3 approval, and he had a I-140 with company A under EB2 approval, and he got the and the prior dates are not current in EB3. He got an approval in the EB2. What do we do in this?
Yeah, it is kind of perplexing. There are so many applications that are eligible to be approved. The priority date is current and they're just waiting. And then there are these odd approvals that they actually shouldn't have been approved yet. They're being approved before the priority date is actually current in the category that it was filed in. But it is happening, a handful of cases, and I believe in those cases they have reached out to UScis.
Yeah, when I reached out to UScis, Rebecca, what they pointed out very clearly that they have an authority to go back and find any I-140 approval under EB2 and get the green card approved. That's one time that I got inquired. I charged the client $2,000 for telling the same thing. Unfortunately, that you don't have to do anything. Then I had another client where we inquired into UScis, Rebecca. They approved, this guy had never had EB2. He had only EB3 approval all along. And his priority date is not current right now. He got the green card. And when we inquired into UScis, the UScis, after paying $2,000 to us, we inquired. What we found out was that the UScis told us that when the priority date was current, though, they allocated a number to this person. Since they are already allocated the number to that person when the priority date was current, they don't need to look into today if the priority date is current, since the number is already allocated. So that's what they said. So practically what I'm telling all the clients is, it's always good to have a consultation, but most of the time what I'm telling, instead of charging them a lot of money, I go through the entire situation in consultation. I tell them one thing: if it's approved in the wrong category, I still recommend people to go have a consultation. This is what I tell my clients: shut up and do nothing. That's exactly what I'm telling them. If it's approved in the wrong category, that's what I'm telling them. Any other things that you have suggestions on this?
Yeah, there's not that much you can do. If you reach out to UScis and tell them that it was approved before it should have been. I've had a couple of consultations also where I didn't reach out, but they reached out personally to the customer service line or even to the Ombudsman and received the same response from UScis, basically saying your green card is approved, you don't need to do anything. I know people are concerned that this could cause issues potentially at the naturalization stage 5 years later. And we do know that in some cases UScis at the naturalization stage has looked back into the green card and whether it was issued properly. But I would say if you did reach out to UScis to inquire about the early approval, just keep a record of that, of the, maybe the service number of the call that you made, and just show that you were aware of it and you tried to contact UScis about it, and just sort of keep a record of it in case it comes up later.
Dates of filing and final action dates. Until recently, Rebecca, they were using dates of filing. Right now, they said it's a final action date. What do you expect in the months of August and September? Will it be dates of filing or final action dates?
Yeah, we expect that UScis is going to go by the final action dates chart only, chart A, for the rest of this fiscal year, which means through the end of September 30th, that they will only accept chart A, even if chart B keeps being published with dates that are farther ahead. Actually, the amount of time that UScis used chart B this fiscal year, was a lot longer than normal. In the past, they've always only at most used chart B through, maybe the third month or so of the fiscal year, through like December. They continued using it into the spring this year, so they did accept it for longer than usual. So they are not accepting it, chart B, for July, and so we're expecting that means they are not going to accept it anymore for the rest of this fiscal year.
What do you expect for the month of October of 2022?
They normally historically have allowed using chart B at the start of the fiscal year.
You're expecting it filing dates?
Yes. to be used in
now
October.
based on the pace at which the USCIS is going though, and when I see some of these approvals coming with the wrong things on it, and they're approving left and
Going
right
very fast,
though. What do you expect? Could you expect all 280,000 green cards to be given? What do you expect the priority dates movement in October of 2022?
That's the hope, definitely. And I mean, the administration does seem, they're at least all the statements they're making and the actions they're taking in the recent month or so does seem to back up the fact that they are committed to using as many of the employment-based visas as possible. And a lot of that is due to, you know, activism on the part of, you know, our audience, contacting Congress people and making them aware and putting pressure on USCIS about the wastage of green cards in previous years. So USCIS does seem to have received the message. The fact that they even are publishing as detailed a list of FAQs as they are seems to indicate that they are, you know, listening and are trying to do what they can. I don't know if they will get through all 280,000. That would definitely be the hope.
I mean, we have put our people are writing so many letters to the congressmen. We expect everybody in this, those people who are listening to this, if you have not already written to the congressman or senator, you should. We have given the details to you. We have some additional details that we have given though, especially the letter that we drafted in the past 2 weeks. Please watch that letter, because there are some things that we learned from USCIS that they can allocate the number earlier, which we were not aware of it. So what we're recommending right now is, why can't you allocate the numbers to all the people right now, and then you can adjudicate them next year if by any chance. I mean, we want them to adjudicate this year, but if any chance it goes by next year, then you can always put it back if you needed to. So we're telling them to allocate the numbers to all the people whose priority date is current immediately. That's what we're recommending. So we changed our letter. We want you to write the letter. If you have even written the letter 2 weeks before, we want you to write the letter again, which we have given the draft. And if you, there are some other things on the adjustment of status I want to update is that we have said before that we have not seen any interfiling cases getting approved. That is not true anymore. We have started receiving the approvals for the interfilings. It's not to the level that we expected though, but yeah, they started coming right now for the interfiles though. They started coming in the month of May. I think so. There may be one in April. I don't think so, but mostly in the month of May, we started receiving the approvals for the interfile cases under EB2 cases. EB2. Rebecca, what's the update from CBP? Let's say, for example, my name is Rahul Reddy. Instead of Rahul Reddy, my I94 comes in as something else. Can I get it corrected? My I94 gets corrected though.
Yeah, so CBP has a website now called an information correction form, where you can submit an electronic form requesting a correction of the I94 website. So it does look like...
The link is provided at the bottom of this page, guys.
It looks like it is only for the electronic I94s, not for paper I94s. And CBP has emphasized that it's only to be used to correct typos, like errors made in entering the data by the officer on the electronic I94. So it's not meant to be used for a situation where the officer does have the discretion of shortening an I94, which they do in some situations. For example, in a situation where your passport expires before your I-797 approval notice expires, officers do have the discretion to shorten your I-94 to the end date on your passport rather than the end date on your I-797 approval notice. So for something like that, that's something that they would not accept through the information correction form, because in their view it's not a mistake. Something like that would need to go through CBP deferred inspection, which you could either go in person or email CBP. But we do want to emphasize that if you are going to request a correction or an update to your I-94 from CBP deferred inspection, for example, going in person, and your I-94 has already expired, if it's past the validity date on that I-94, definitely consult with an attorney before going in person to CBP.
They may lock you up, detain you if your I-94 expires, so be careful on that. But if there is a simple corrections, for example, if you're coming on H4, they give you H1B, you're coming on L1, they give you H1B, or vice versa, though, that's definitely a thing that you can do it online correction. The link has been provided in there. We're going to go to questions. First question that comes from Ravindra Annapareddy. Are there any denials for any reason for 485 applications? Not from our office, no. We haven't got, for the batch that we filed in October 2020 to right now, we haven't got a single denial yet. Not that it's a guarantee that future will never be denied, but no, we did not get any denial. One thing, Ravindra, is that it's very rare we see a 485 denial. Because that's going to be, if we get the 485 denials, it's going to be a court case. There's going to be a lot of things involved in it. So definitely, very rarely we see 485 denials.
Jitin from YouTube has an update more than a question actually on his case. He said that an H1B, H4, and EAD that were all filed together were approved by UScis all at the same time, which is very rare ever since 2019. So I would say that is still kind of an outlier, although we have noticed the same in a few cases filed through our office where the H1B and H4 are filed together. As you know, it used to be that the H1B could get approved within 2 weeks in premium, but the H4 would take 5 or 6 months more to be pending. But we have noticed in some cases that they're being approved at the same time. So this may be UScis kind of also making good on their promises to improve H4 processing times and to get it back to a more reasonable level, although we would say that it's definitely not every single case. That is, it's not across the board that H4s are all being approved at the same time as the H1B, just in some cases.
Question from Shashi coming. He interfiled and he got his, it's not from Shashi. It is from Shashi. He filed EB3 to EB2 interfile in the first week of January 2022. When should I expect the receipt notice? Well, if you have interfiled in January, first week of 2022, most probably what you did is that you wrote a letter, you did not file a 485J supplement. So you may not get a receipt notice at all though. But what I recommend is that if you have not filed a 485J supplement, and if you have not sent to California address, which only existed in the last week of January of 2022, you should send your 485J supplement to upgrade to EB2 to the California address. Don't wait for them to act on it. Please act as soon as possible. File it again, please.
There's a question from YouTube about an I485 interview being scheduled and what to expect. So as we were mentioning, the majority of I485 employment-based are still getting approved without the interview. If you did get scheduled for an interview, I would say the majority of interviews that we're seeing, there is some kind of slightly unusual issue going on in the case, maybe something in the immigration history that UScis wants to inquire about, or potentially a criminal matter, or there are some cases where if the I-140 that your I-485 is based on, the company that filed it, sometimes the company itself, just all their I-140, I-485s get called in for interviews because of, for example, maybe a successor of an interest issue with the company. So if you have been scheduled for an interview and you're not really sure why, it may be helpful to consult with an attorney to go through your immigration history and try to find out what may be the reason for the interview and prepare accordingly.
Mandan has this question. He has filed an amended EB3 in October of 2020 and it got approved in 2021. Am I eligible for interfiling? Priority date is April 2012. The best proposal that I would suggest you, Madan, is that to file an I-140 under EB2 again and do it convert into premium processing. Once you get an approval, you then go for the interfiling though. The reason is that we have already suggested in September, October of 2020 that never file as an amendment. unless there is a company name change or tax ID number change, never file as an amendment, only file as a new application. But I don't know, some of the lawyers didn't know it. And the USCIS later on clarified the same fear that we had in September and October of 2020, that the EB2 I-140 is no longer valid if the EB3 I-140 amendment has been approved. So it's better that you refile the I-140 under EB2 than do interfiling.
Momo from YouTube says that their I-485 has been pending for about 3 months. The derivative was scheduled for biometrics, but the principal applicant has not been. So whether there's anything that needs to be done in that situation. So we do sometimes see cases where the family is not all scheduled for biometrics at the same time. I would say most of the time, an entire family, if they filed the I-485s together, they're scheduled for the biometrics at the same time, and for the most part their I-485s are processed at the same time, but it's not always happening. In this case, if the derivative has already been scheduled for biometrics but there isn't anything yet for the principal, I might try calling USCIS and just see if the representative can give you any information on whether the biometrics notice was sent, but maybe it got lost in the mail somehow and didn't reach you, to just find out whether in their records they can see a biometrics appointment was scheduled or not. If there wasn't, then there isn't that much that you can do, I would say, to expedite a fingerprint appointment. I know there's another question about that. Is there any way to expedite the biometrics appointments? Not really. Those are scheduled by the application support centers, the ASCs that are local to your area, and so the main USCIS office doesn't really have any control over that. It's based mostly on their backlog, but you can try calling maybe to see, just to make sure you didn't miss a biometrics appointment that was scheduled.
Deja vu. This is from Atul Mohan from YouTube. In October of 2000, going to repeat again in October of 2022. That is EB3 surpasses EB2, say 2016, 17, 18. Well, anything can happen, Atul. That's one thing that USCIS and State Department learn now, which those stupid fellows should have learned before, that the people can convert into EB3 to EB2. So in September of 2020, though, they looked only into the stats. How many I-140s are approved? How many are EB2? How many are EB3? They just went with the stats. They didn't know that people can downgrade from EB2 to EB3. I don't know how they didn't know. Now they learn right now, oops, there are people who can do downgrade applications. So because they now learn that all EB2s, or at least 90% of the EB2s, can be converted to EB3 though, we may not expect the same thing where EB3 is going to surpass to a greater extent though. It may surpass, I'm not telling it cannot, but I don't think so it's going to surpass the way they did it, because in October 2020, the priority date was somewhere around May 2011 for EB2, but it was January 2015 for EB3. I don't think so that's going to happen again. I don't think so. These people who live in Mars, which is USCIS, and the State Department who live in Venus, now they have come to Earth. They did understood at least one aspect, that we can downgrade.
Joy from YouTube is asking whether she should interfile or file a new I-485. So we have discussed, the pros and cons of interfiling versus a new I-485 filing in the past. I would say at this point where we are in the fiscal year right now, I would probably lean towards interfiling. If your date is current in the EB2 category and you have an EB2 I-140 that's approved that you can interfile to, that you can transfer to, personally, I would opt for that right now because of, as we mentioned earlier, USCIS has stated that they are targeting to approve any eligible I-485s that are able to be approved that were filed and received by early June 2022. So assuming your I-485 was already filed and pending well before June 2022, and it's the only thing keeping it from being approved right now is being in the EB2 category, I would definitely file a J supplement, transfer it from EB3 to EB2 if your party date is current in EB2, because once that is done, your case should be eligible to be moved to the National Benefits Center and adjudicated. And I would say earlier this year, we weren't as certain on how effective the J supplement interfiling was going to be, because from the time it was announced, it was like months before we got some of the first receipt notices from those J supplements. But we are getting those receipt notices pretty consistently now, not always automatically, like right away within a few days, but we are getting those receipt notices, and USCIS has stated multiple times that they are basically scanning those J supplements to the service center where your I485 is, and so they have a system, it sounds like, of effectively kind of updating your file with that interfile request. So at this point right now, I would lean more towards interfiling if your date is current in EB2.
Pradeep has a good question with regards to, he has interfiled to EB2, but his underlying I-140 is not approved. Do we recommend doing a premium processing? Pradeep, we do have the YouTube channel, we do have the Facebook, we do have the TV Asia, where me, Emily, or Rebecca comes in there every week on Sunday. We do have a daily conference call where almost 60 to 70 people, or sometimes even 80 people come in. Every single day. It's been going on from 2012 to right now. Anybody wants to, please, a conference call number, a Zoom conference call number is there at the bottom. You can join our daily Zoom conference call and ask live questions. It'll be either mostly me or Rebecca will be there to answer those questions. Every day, half an hour free, you don't have to pay any money. We do get a feedback from the people when they get the green card. What kind of green card? For example, when they interfile the medicals, some people's interfiles went through. They said, thanks to us. Some people said it did not went through, they got an RFE. That's what we expected. Not 100% is guaranteed in those things. At the same time, when people have interfiled, previously we said, no, we haven't received it, but of course we did receive it. Now people are telling in the chat that they have received the green cards after interfiling. After refiling, people have got the green cards too. Now the question for you is that, have we noticed anybody whose I-140 is not approved getting the green card under EB2, even though your I-140 under EB3 is not approved? We have not noticed it, Pradeep. We have not noticed it. So if anybody has got, when their I-140, EB3 I-140 is still pending, and you have filed based on the EB3 I-140, now you interfiled, you got the 485 approved, please let us know. Please let us know. In cases where we also noticed, Pradeep, that where people have filed an EB3 485, it's not approved I-140, they have refiled under EB2. Now, in refiling cases, we expect them to independently adjudicate the 485 because EB2 is there, so they should be adjudicating it. In that case also, they did not adjudicate the 485 under EB2. That was surprising for us. Now, of course, there are some trials and errors that we do, so that's very surprising. So we, at this point of time, Pradeep, we strongly recommend that you do the premium processing for EB3. It's definitely worth the money, though.
Paul from YouTube is asking about an H1B registration that was selected in the lottery, but the employer is not willing to file because there is not an end client letter, and if there are any options to proceed in that situation. So unfortunately, there's nothing that the beneficiary can do independently of the H1B petitioner. So the H1B application can only be filed by the employer that registered that selected registration in the lottery in March. It can't be transferred to another company, and the employee is not able to file on their own independent of the company. However, if the company is, as long as there is actual work for that employee, if they are actively working on a project or there is ongoing work, and if the only thing that is holding up the employer is the end client letter, the end client letter is not always needed anymore, ever since kind of the litigation that kind of negated the need for the chain of documents from the employer to the vendor to vendor B to the end client, and all the work orders and letters from every vendor and every client, those are not all needed necessarily anymore. I would say as long as there's proof of the work that the beneficiary is doing or expected to do in the form of, for example, a work order, just the fact that the end client is not providing a letter should not be a reason in itself to not file the H1B application.
Arpit Nagar, EB1A I-140 has been approved. Is it a good idea to apply for I485 with a company attorney or a personal attorney? It doesn't matter, Arpit, to either go with a company lawyer or a private attorney though. But if the company lawyer has handled your EB1A, I would stick with that company lawyer because he did all the hard work for getting an EB1A approved, which is really not that easy to get it as compared to the 485 application. Though I would stick with that person. But that lawyer, if I were you, even if he's charging a little bit extra money, is definitely worth his weight in gold.
Ron from YouTube is asking if his prior employer that he's no longer working with withdraws the I-140 approval that they filed for him, can that I-140 still be used to extend the H1B beyond the 6-year limit and as the basis for H4 EAD applications? So the answer is yes, as long as that I-140 with employer A remained approved for at least 180 days. So as long as it remained approved without being withdrawn for at least 6 months, even if employer A later withdraws that I-140 or you're not working with that company at all anymore, you can still use that I-140 approval to extend your H1B in 3-year increments with any other company, and your spouse can use it to apply for the EAD.
Brijusha, he got the he filed the AC-21-485J and got approved within 4 weeks after filing a AC-21. Can he now change the job? Will it cause any problem in the green card? Absolutely, you can change the job. You can flip a burger in McDonald's, you can be a Microsoft CEO, you can just sit at home and do nothing. And still, you will not have any problem for your green card, will not have any problem for naturalization. One thing I tell you that, don't sell the drugs. I mean to say the marijuana or those kind of things. So they are illegal under the federal law. No matter what the state law say, that's the only thing we suggest you not to do, that we can tell. And there's a lot of rumors there that saying that you have to stick with the company for 6 months after you get the green card. I don't know where they come up with the rule. That's no longer exists. Once you get the green card, you are free to do what you want to. That's the whole reason. It is the job, it is the prospect of the job, it is the prospect of the job, that the job offer is there, that is giving you the green card. So that is over now. Your term is over. You can do whatever you want to.
Ram is asking about his spouse's H4 EAD, which is valid until 2024. He is in the process of transferring his H1B to a different employer and asking if the H4 EAD will remain valid through the transfer or if they need to reapply. So the H4 EAD is not company specific the way your H1B application is. For the H1B, you're only authorized to work for the company or companies that sponsored your H1B visa, but for the H4 EAD to be valid, it just requires that you, as the H1B employee, be working actively in valid H1B status. So your wife's H4 EAD does not need to be reapplied every time you transfer. So as long as it is still unexpired, it can be used. But one reason why you may want to apply for the I-539 and I-765 anyway, even though it's not really necessary right now, it's not expiring for more than 2 years. As everyone is kind of aware, the H4 EAD processing time is taking a while, and so in general, if you're filing the H4 EAD separately on their own, you can't file for them earlier than 180 days from the current validity end date. So you wouldn't be able to apply for the EAD renewal until June 2024 if you're applying for it on your own. But if you're applying for them all together, the H1B transfer, H4 and EAD all together, for now USCIS is still accepting H4 and EAD applications filed earlier than 180 days of that window if they are filed concurrently with the H1B. So if you want to avoid a potential situation where the EAD does not get renewed in time, you may want to go ahead and file the H4 and EAD together with your H1B transfer, even though you don't absolutely need to.
A question that are related to the I-131, also called as advance parole though. At this point of time, USCIS is of the opinion that if you travel an advance parole and if you have an L1, L2, H1 and H4, they will ignore that you traveled an advance parole. They will still consider you as an L1 or L2 or H1 or H4. That's how they are. You can extend it, you can transfer it to a different company. In the case it's H1B and H4, you can do that, absolutely no problem. We have done several times after people have traveled, no problem with that. Now, next question that comes up is that my I94 for advance parole is expiring. They normally give an expiration in 1 year. What's going to happen afterwards? You can completely ignore that. You can ignore that expiry date. That's one time I tell people that if the advance parole, the I94 says it's expiring in, let's say, 1 year, and then you cross the 1 year, you're perfectly legal to stay in the country. Patabi is asking the question that did the USCIS released any stats on the I485 inventory? Unfortunately, not yet, Patabi. They used to release much faster though. Right now, they're very delayed. We only got the information until December 31st of 2021. And they released in the later weeks of the March of 2021. So we will get one update right now in this month, but that will be only until March of 2021. That is not until June of 2021. You know, the government puts the rules on other people when it goes to the when it goes to the quarterly reports of this publicly traded company. They need to report it. If the quarter ends in June 30th, they need to report it within certain time. They don't follow, you know, they don't have any rules for them, unfortunately. They release it much later. So the information that is up to March 30th, most probably we will receive it by June 30th though. So that's definitely not a good thing. That's the reason why we are unable to take a stance. We don't know where they are, how many cases are in the inventory, how many cases are approved. By the time we looked into last time, December 31st of 2021, there are about 250 or 260,000 green cards applications pending. So they had just enough to adjudicate all the 485 applications by the end of this fiscal year, which is September 30th of 2022.
Karthik from YouTube is asking if he can submit the interfile request if his EB2 I-140 was just recently filed and is still pending. It's not yet approved. So yes, you can submit an interfile request to an I-140 that is not yet approved. That is in the guidance from USCIS when they released the instructions on the transfer of underlying basis earlier this year. They said that you can interfile from an approved or pending I-140 to another pending I-140. So you can just submit the J supplement with a copy of the EB2 I-140 receipt notice. Also, even if your I-140 and EB2 is not yet filed, if you are planning to file it and want to, and know that you are planning to interfile to EB2, for people in that category, USCIS did mention to include a cover sheet with the I-140 petition stating that it is going to be used as the basis of a transferred I-485. So for anyone who is in that category about to file the I-140, make sure you include that cover sheet as well.
Seshu Sandeep has this question. He is born in Bahrain and he filed the 485 based on cross-country chargeability though. As people must be aware that people who are born in Bahrain, they still will not get a Bahrainian citizenship, they still will be considered Indian citizenship. But when it comes to the cross-country chargeability though, they will be considered as a Bahraini quota. So his priority date is EB3 current or most of the time, even right now. So it's current. I mean, he doesn't have to look into the priority date. His question is that he doesn't have the birth certificate, but he has a document from the Indian embassy. Shishu, you probably, if you don't have a birth certificate directly from Bahrain, though, you definitely need a lot more evidence than that. I don't know what the rules of Bahrain is. If they are going to issue the Bahrain birth certificate, you should try to go and get it though. If I were you, I would fly to Bahrain and try to get the Bahrain birth certificate though. That's how important it is for you to get it. Hire a lawyer in Bahrain to get the birth certificate from there, and try to get the hospital record there at that time, and try to get every possible thing that shows that your parents were, particularly your mother, was there in Bahrain at the time of your birth. For example, her travel tickets, her information that's there though. So try to gather all the things, because they may issue an RFE. You don't want to collect it at that point of time. You may want to collect it very in advance before they issue an RFE.
Swati filed her I485 application recently, but it was rejected due to incorrect fees, and is asking whether the 1225 fees needed to be separated into two checks of $1140 and the $85 biometrics fee. So that is not really necessary. We normally file the I485 application with a single check in the amount of $1225. It's not necessary to separate them. I would take a look at the checks to make sure there isn't anything else that was missing or incorrect on the check. When the I-485 gets rejected, USCIS is usually not very specific on the rejection reason. Sometimes they will just say, you know, insufficient payment without stating exactly what was wrong. So one thing to keep in mind is that the check needs to be dated within 6 months of filing the I-485 application. So if for some reason the check was dated more than 6 months within the time you're filing, you'll need to get new checks that are dated more recently. Make sure the signature is there, make sure everything is spelled correctly and everything is legible, and that it's made out to the U.S. Department of Homeland Security. If all of that is correct, then it may just be an erroneous rejection. We have also seen that from time to time. The mailroom just makes a mistake and sends something back mistakenly. If that's the case, just have it resubmitted with an explanation, and if needed, request that the original receipt date be retained for the filing.
Sandeep from YouTube has this question. His credit score got messed up after filing the 485. Will it have any impact in getting, will it have any less chances of getting the green card? Absolutely not. And it will have a zip impact in you getting the green card. You should be fine in getting the green card, even if your credit score is messed up. Not a problem at all.
Kamlesh from YouTube is asking about the EB1 category and whether USCIS is also committed to adjudicating those. It sounds like his EB1C I-140 has been pending since September 2021, and if there's basically any hope of the green card getting approved this fiscal year also. So yes, I would say that USCIS is slowly making progress on the EB1C backlog. There had been, even as of a few months ago, the EB1C I-140 backlog was incredibly long. We had had some cases pending since the summer of 2020 with no movement at the Texas Service Center, for example. But just in the past couple of months, I would say, we've seen EB1C I-140s getting processed faster. The ones that we had from 2020 were suddenly approved. I had one recently approved that was filed last summer, 2021. We also have been getting some EB1Cs approved in a surprising amount of time, within 90 days, a few months of filing. So some that were filed this year are getting approved this year. So USCIS does also seem to be committed to kind of getting through the EB1 I-140 backlog, because those are also easy I-485s for them to adjudicate that would add to their goal of
what about the premium processing update, Rebecca?
Yeah, so that's another thing that they introduced as of June 1st. Any EB1C I-140s or NIWs in the EB2 I-140 category that are pending from before 2021, January 2021, can be upgraded to premium processing. So it is pretty limited. It doesn't really, for example, for Kamal, the person with this question, it won't help you, that premium upgrade, since yours has been pending since September 2021 and they're only accepting upgrades from before January 2021. But the hope is that they will expand the premium processing for EB1Cs. As the year goes on, hopefully they will make that more available. To not only pending applications to be upgraded, but for new I-140s in the EB1C category to be filed initially in premium processing.
Question that comes with regards to the PERM, this is for Vikas. PERM is taking approximately 5.5 months to about 7 months right now, Vikas. That's how long it is taking. It's taking right now. Akshay from YouTube has a question. This is a little bit sensitive question. His priority date is March of 2018, and he also has a Canadian PR. What do you suggest to move forward, though? Will the priority date be current for him? Now, that's going to be a tough question, actually, for me. Normally, I suggest people to keep the Canadian PR on the side. I mean, given a chance, if I'm just a fresh immigrant right now, to go through the immigration process and go to the immigration law firms, the HR and all those things, I would just get the green card in Canada, move out of this country, believe me. As an immigration lawyer, with the knowledge that I have, if I'm just coming freshly, I would do that thing. Now, you have question is, previously they used to give PR, that was my knowledge. I'm not a Canadian lawyer, guys, so don't take anything what I say about Canada. Previously they used to give Canadian PR, and then you don't have to stay there. You can stay there, you can keep on renewing green card. That's how it used to be. Now they put a condition that you have to stay there for a particular given time, though. So that's really a judgment call, especially if your priority date is March 2018. I cannot give an opinion on that. It's up to you. How do you take it, though? If I'm a fresh applicant, yeah, I would definitely go to Canada rather than stick here for 40 years to get the green card. Definitely I will go to Canada, but it's 2018, I can't tell.
Vicky from YouTube is asking, is there any way to check whether a medical exam has successfully been matched up to her I485 file? It sounds like it was sent in, she tried interfiling it about a year ago. So unfortunately there isn't a way to confirm for sure whether your medical exam made it into your I485 file, and that was something that UScis was mentioning in their FAQs, that with files being transferred from service centers to the National Benefit Center, and then from the National Benefit Center it can be transferred to a field office that's not necessarily the field office in your city, and you may not get a transfer notice actually when it's moved from the National Benefit Center to the field office. So it can be difficult to know where your file is physically, and that's the difficulty with sending in a medical exam without an RFE or instructions from UScis. There isn't a way to confirm whether it has been matched up, but I would say one thing you can do to prepare is if you just be prepared for getting an RFE on your medical exam, so that if you do receive that RFE, if you have the exam handy, you can send it in right away. With the elimination of the 60-day window to file it with UScis, you can get a medical exam now. I know it's still pricey and you may not want to spend the money to get an exam that may not be necessary, but if you don't mind, I personally would get an exam right now and have it ready to send in at a moment's notice as soon as you get an RFE. Another thing to keep in mind is that based on what we saw at the end of the last fiscal year, like August, September last year, UScis was kind of frantically trying to adjudicate as many I-485s as they could, to the point where officers were calling people on their cell phones to send in the medical exam. So that's another thing to keep in mind. Don't be surprised if you actually get a phone call potentially from an officer asking for the medical exam and instructing you on where and how to send it in.
Hey guys, I just want to be a little bit cautious. If they're asking your credit card, if they're asking any money, it's not legal, guys. Yeah. Please, there are a lot of fraudsters that are doing it. But these fraudsters are not interested in medical, that's for sure. We are aware of it. They don't care about your medical, so they are interested in your money. So if anybody is calling you and asking money from the government official, we also notice that they say they are from IRS, Social Security Office, USCIS, Department of Homeland Security, ICE. They will name anything you want to, and these are fraudsters. They're asking money. The government officials will not ask money, though. They will not ask you credit card. They will not ask you to send anything. We receive a lot of complaints from these fraudsters. Be careful on that. Surabhi Verma is asking question, after how long after you get this green card can you apply for the US citizenship though? Assuming that you're not married to a US citizen, you can apply in 4 years and 9 months. You can actually apply 90 days before the 5th anniversary of your green card. That's when you can apply. I normally tell people to apply 85 days, not 90 days. The reason is that if by any chance you do a miscalculation, if you apply in 91 days, they will take your money, waste your 1.5 years, and they will deny your citizenship. That's the reason I recommend people applying 85 days before the 5th anniversary. When people ask questions, is it on the day I receive the green card, or is it on the day that the green card is approved online? Always check the date that it's been approved, especially when you receive an online notification saying that your green card is approved. That's the date that will be the date that the permanent resident sends, whatever the date it is. From that day, you count 5 years and you deduct 85 days from there. That's when you can apply for citizenship. And typically, if you apply for citizenship, anywhere between 8 months to about 16 to 17 months is the processing time for you to get the citizenship. People also ask me questions with regards to how complicated it is, citizenship. Believe me, if you don't have any criminal records other than just the traffic tickets, if you don't have any absence outside the country on a single stretch for more than 6 months, that means if you visit like 2 months, 3 months, 1 month frequently, that's fine, okay? If you don't have any criminal records or absence of more than 180 days on a single stretch though, we normally recommend people apply online. I mean, I would recommend people, if I were you, not having knowledge, not being an immigration lawyer, I would apply online. Believe me, it's so simple application. People can apply online. It's a very easy application. You can apply online.
Hemant is asking for someone in H1B status, how long can they be without being paid on payroll? So technically, when you're in H1B status, in order to properly maintain H1B status, you need to be working for the H1B petitioner according to the terms described in that application, including the salary level that they have listed in the LCA that was filed on your behalf. So technically, once you are not meeting those conditions, you can be out of status immediately. But there is a 60-day grace period where if you are terminated by the H1B employer and they are no longer paying you because you've been terminated, if your I-797 approval notice and I-94 are still valid for more than 60 days from the date of your termination, there is a 60-day period where you can have another application filed for you, a transfer application or a change of status application filed within those 60 days, and it will not be considered late.
Venkat Gangineni has this interesting question. How many green cards are expected family-based to employment-based for the fiscal year of 2023? The estimate is at this point of time anywhere between 50,000 to 100,000. That's the estimate that's there. We'll see based because most of the green cards for the family-based are given outside United States. They are given in the consulates though. USCIS adjudicate most of the employment-based green cards though. Consulates don't. So consulates are very backlogged. Their limitations are very, they're not as functional as the USCIS is based on the COVID and other rules that they have. So they're still backlogged a little bit. So that's probably is a good news for the employment-based green card guys. We may have still spillover just like the way what we had in the fiscal year of 2021 and fiscal year of 2022. We will have a spillover in 2023, but our estimate is between 50,000 to 100,000, somewhere between that. Anything else, Rebecca?
No.
Thank you guys for tuning in. If you want to have a consultation with any of our colleagues, you can go to our link. You don't have to pick me all the time or Emily. Rebecca has been, she's been in immigration since she's, I don't know, from high school. She's been working in immigration law firm. She's been associated with our law firm from 2010. That's 12 years now, yeah. from 12 years. She's been associated with the law firm, so you can have a consultation with her. And don't forget that we do have a free daily conference calls. You can Zoom calls where you can ask live questions. The links are provided. Don't forget to write letters to the congressman. We have given a fresh letter, so next time we will try to answer more to the people who have written the fresh letter to the congressman, because we want the 280,000 green cards to be given to the people who have been waiting for a decade, some of the people that you are. So we want those green cards to be used, because if we don't use those green cards, they're not going next year to us. They're going to go to trash, and you will be waiting for a long period of time. So make sure you write the letter, your friend writes a letter, everybody writes the letters. The drafts have been created and put it down there. Please use those things. Thank you guys for tuning in.